Kelly?
SJC 12485, Warren Yee v. Massachusetts State Police.
Okay, I'm excused from both of these. Oh, no, this.
Yeah, they were both on.
They're both, okay. Okay.
Mr. Margolis, good morning.
Good morning. Lieutenant Lydon, the comparator here, the primary comparator, was really the perfect comparator. He was transferred only a few days after Lieutenant Yee had sent his letter complaining of the failure to transfer him to the superintendent. He was approached about the transfer on the day that his promotion to lieutenant from sergeant became effective, so he had zero experience in the rank of lieutenant. He was white, as were all 12 of the people transferred from 2008 when Lieutenant Yee made his request for transfer to Troop F until the summary judgment motion in this case. He came from the same troop as Lieutenant Yee, and when he was involuntarily transferred back, he was transferred back to the same troop that Lieutenant Yee was in. While he was at Troop F, he earned over $30,000 more in total compensation than he had when he was at Troop H, and he testified that when he went back to Troop H, his compensation annualized went down by over $30,000. It's hard to think of stronger comparator evidence than that.
But it's odd that we only have one of 12 comparators, right?
Well, Your Honor, first of all, I would note that...
Let me just pose one second part of that. I mean, we know also that different people get overtime for different reasons, right? We don't know whether the other 11 didn't want to work overtime. You know, we just don't know very much, do we?
I think there are two factors there. First of all, the single comparator. Suppose this were a single comparator case. Mm-hmm. Would we say, but you only have one comparator? You have those cases all the time.
Right, but the problem is this isn't a single comparator case. There are 12 comparators. I don't know whose responsibility that is, but it just seems odd that the critical question is going to be whether these 12 people got more overtime when we only know what happened to one person.
Well, Mr. Justice, the state police had the burden of showing there was no disputed issue of fact. The state police could have presented evidence on what all or some of the comparators earned.
So it's
they did not do so.
So it's a material disputed issue of fact because we have one person, but we don't know about the other 11.
Right. I think we can all agree, if there's one material issue of fact, summary judgment must be denied. There's another issue here, and that is the question of what a person actually earns, it seems to me, is not the essential question. It's the opportunity to earn additional overtime and details.
But isn't that where the record's scant as well, where we don't know what the availability of overtime and details at H was, and we don't know really the availability, other than anecdotally, at F? Because we don't know what Yee had worked at H, how many details he worked, how much overtime he got. We don't know how much all of that was available at F, other than everyone saying in his letter, he says, I want a lucrative position.
Well, Your Honor,
as I retire.
Again, we have evidence from Lieutenant Lydon that his income went up and went down again when he went back to the same troop as Lieutenant Yee. Now, two lieutenants in the same troop may not have identical opportunities for overtime. It may depend on shift. It may depend on particular assignments that they get. But again, it's equality of opportunity is the key to our anti-discrimination laws. There's a reason, as we suggested in the brief, why the Federal Anti-Discrimination Agency is the Equal Employment Opportunity Commission, because we have recognized for many, many years that opportunity is a key. And I suggest that that's the case here. It was the opportunity to earn additional income. Now, it may have been that had Lieutenant Yee been transferred to Troop F, he would not have earned as much overtime as Lieutenant Leyden. Maybe he would have earned more. Perhaps his situation would have changed. Perhaps he wanted to go to Troop F because he had a child who was approaching college age, and he said, you know, I could use more money to pay for the college. And
your client has no obligation to show the maybe or the why in the record? Because as I understand it, that was Judge Wilson's concern. It seems like we all recognize that refusal to allow a lateral transfer can be an adverse employment action, but it seems like Judge Wilson was saying, well, we don't know anything about Lieutenant Yee and what Lieutenant Yee would have done. And so, therefore, he found that there wasn't enough information and that the burden was on your client.
well,
Is that right?
that's what he found, and I suggest to you that that's clearly erroneous. The plaintiff said, here's the reason why I want to go to Troop F. I'm not sure that it was incumbent upon him to say that. The state police didn't ask him why he wanted to go to Troop F. He said, I want to go there. Lieutenant Leyden's testimony establishes very clearly that the potential was there. Now, we cannot say what would have happened in the future. If you have a failure to hire case, we do not deny a plaintiff the opportunity to get to trial because we say you might not have succeeded in the job.
Yeah, but this is a little different because you need to create a material difference in the same job. So it's critical that you establish that you can earn more overtime at Troop F than the other troop, right? That's essential, or there's no adverse issue here, adverse employment matter.
But that may be, but I suggest that
That's different from a failure to hire case.
well, that may be. I'm not entirely sure that it's that different, but let's assume that it is. Your Honor, again, we have strong evidence here that the opportunity was available. And, I mean...
You have Leyden's evidence. That's it, right? Is there anything besides Leyden that... I'm not saying that's not... I'm not saying that's not enough, but we're just guessing.
Well, but we're not...
We don't know anything about the other 11 or the amount of overtime that's earned at the other troop, right?
Well, we know that Lieutenant Yee expressed an interest in overtime. I think a juror could conclude from that, given the absence of any contrary evidence from the state police, which again had the burden of showing there was no disputed issue, that his expression of interest was honest. Indeed, at this stage of the proceedings, the court must accept his declaration as being truthful.
Are there any cases that you found? You mentioned one case that there's one comparator. At least you pull out a sentence in your reply brief. Are there any cases where summary judgment is denied because of there are multiple people involved and you only have evidence from one? Is there anything we can turn to for guidance on that issue?
I cannot think of one offhand, Your Honor, but I think it's clear that what do we need? Suppose this case had been tried to a jury on this record and it came up on a JNOV. A JNOV would be denied because there is competent evidence from which a reasonable juror could conclude that Lieutenant Yee wanted additional overtime, and that was his reason for seeking the transfer, that there was additional overtime available at Troop F because Lieutenant Leyden, who was transferred there at the time that Lieutenant Yee was, indeed within a few days of his letter to the superintendent, that he earned substantial additional overtime and details, and that when Lieutenant Leyden was transferred out of Troop F, and again, back to the same troop as Lieutenant Yee, his income declined. That's plenty of evidence for a reasonable juror to conclude that there was real harm here to Lieutenant Yee. If he can then show at the trial that the reason for refusing him the transfer was related to his race, national origin, or age, that's a complete case.
What do we do with interrogatory 12? You asked, I'm not sure whether you were trial counsel. Were you trial counsel?
There hadn't been a trial in this case.
I'm sorry, were you counsel?
Yes.
Were you counsel below? Okay, so you asked in interrogatory 12 for, give me the average overtime and detail pay earned by lieutenants stationed in Troop F for the years 2008 and 2013. Did you also ask for what the average overtime and detail pay earned by lieutenants for other troops?
I don't believe that we did, Your Honor. If you didn't see it, then it's
Okay. Now, what do we do by the fact, I mean, it seems to me that it would be quite probative if it turned out that the lieutenants stationed in Troop F had substantially greater overtime and detail pay than other lieutenants, which is, I assume, why you asked for that information.
If you're really asking me, Your Honor, wouldn't you prefer to have asked that question about Troop H? The answer is, at this remove, yes. And I can only apologize to the court. However, I suggest again that the competent evidence from Lieutenant Lydon makes up for that defect.
Right, well, I know that, but I'm also wondering, you did get an answer as to what the summary was. You got a summary from the Commonwealth. They initially said it's not relevant, which we'll speak to your brother about that initial answer. And then they say, here's the answer, and they give a summary of it. And then after the summary judgment motion is denied, they send you a letter saying, oops, that summary is wrong. And it turns out, as best I can tell, that the amount of overtime and detail pay on average earned by the lieutenants stationed in Troop F were either double or treble the amount that they had initially said. What do we do with that?
Well, unfortunately, at this stage, I'm not sure that, I mean, we may be surprised by the amount of overtime that was there, but I don't know that it really has a burden on this proceeding because, again, we don't have comparable data for other troops, and that was my error. But we have evidence from Lieutenant Lydon.
Okay, I understand that, but I guess I'm trying to figure out whether or not if you had seen these numbers, whether or not it would have triggered a request. I mean, the problem I have is I have a problem with the AG being better off because the AG first refused to answer the question and then did, and then miscalculated it to the tune of understating the amount of overtime and detail pay by either double or treble. I mean, that's an enormous difference. It's a difference between 2011, the difference between overtime being on average $22,570 for the year when it was in fact $86,519. The difference between detail work of $3,492 when it was in fact $13,386. What are you saying that never mind, it doesn't have any consequence here?
Well, Your Honor, on some sense, the tactics of the defense or the inability of the defense to come up with accurate information may tell somehow, but I'm not really sure that it can be taxed against the state police at this point. And again, I confess that we don't have comparable data. But again, we have the testimony of actual experience of one individual. And I suggest that's sufficient to get over the bar for some reason.
I understand. Are we speaking now about the issue of whether or not the prima facie case is met with regard to adverse employment action, or whether an element was met, or are we speaking about the inability to prove damages?
I believe that the Superior Court judge was speaking of adverse employment in the prima facie case, which as the many cases have said, is a small burden easily met. And I would suggest to the court that in addition to the fact that I suspect that there's enough evidence to carry the case over the bar to the jury, or from the jury, that the prima facie case, the small burden, is easily met. I would note, by the way, in the Lewis case from Lewis versus Chicago, which is cited in the brief, the Seventh Circuit said that adverse employment action should not be defined so narrowly as to give the employer a license to discriminate. And I think that's the danger here in casting too big a burden on the plaintiff to show such an action.
Can I ask you a final question?
Of course, sure.
The Attorney General concedes that a lateral transfer can amount to an adverse employment action. Do you agree with the standard they propose?
No, but I think, because I think that there is real evidence here. I think the potential harm is sufficient. I'm not quite sure.
It's the functional equivalent of a promotion, essentially, is the language they use.
The problem is that, especially in police officer cases, the variance in the opportunity to earn overtime and details is great. Ms. Myers and I tried a case in March in which our plaintiff was removed as a detective and made a patrol officer. There was testimony, which I don't think the jury paid much attention to, that you could earn more money as a patrol officer than as a detective, but the detective had more prestige. That resulted in a $2 million verdict.
Okay, thank you.
Thank you.
Mr. Boudou, good morning.
Good morning, Chief Justice Ganson. May it please the Court, Assistant Attorney General Jesse Boudou on behalf of the Massachusetts State Police. The adverse employment action issue in this case is governed by the principles of this Court's decision in McCormick. An employment action to be subject to Chapter 151B has to amount to a material change to a plaintiff's salary, grade, or some other objective terms or conditions of their employment. Lieutenant Yee failed to meet his burden of showing evidence that a transfer would have meant that kind of a material change for him, and so his claims were appropriately dismissed.
So your bottom line is that the hope, the ability to earn extra overtime money is not enough to constitute a material change.
Our bottom line is that Lieutenant Yee's evidence in this case wasn't sufficient to demonstrate a non-speculative inference that if he had received this transfer to Troop F, then he indeed would have made materially more money in overtime.
So you say you have to show that you would have, not that you had the opportunity to.
Well, if we think about it as a loss of opportunity case, which I know my brother was referring to before, the loss of opportunity framework still doesn't change the nature of the evidentiary showing. There still needs to be some objective evidence of a loss of opportunity. So if this were thought of as a loss of opportunity case, it certainly would have been possible for Lieutenant Yee to compare the raw number or hours of opportunities available at Troop H and Troop F, and to perhaps say, I, Lieutenant Yee, have always worked all of the opportunities that I can, but he did not do that in this record.
Is it his burden? When he puts in Leiden's evidence, I understand it's one of 12, and you don't rebut it with anything. Has he gotten over the bar for summary judgment? Because, I mean, Leiden is a good comparator. He goes there, he goes back. You obviously know the data on the other people. They work for you, not the AG's office, but they work for the Commonwealth. Why isn't that enough? It's an honest question. I just don't know the answer to that. Why isn't that enough?
Well, under the McDonnell-Douglas burden-shifting paradigm, establishing the prima facie case at summary judgment is the plaintiff's burden. And the Lieutenant Leiden testimony wasn't enough here, really for two core reasons. The first reason was, as the Superior Court put it, Lieutenant Leiden's individual experience in the 2 years in which he worked at Troop F was completely unconnected to the plaintiff's own circumstances. My brother repeatedly refers to Lieutenant Lydon as a comparator. Indeed, there was no attempted comparison made to Lieutenant Lydon.
He goes back and forth around the time. He's white versus Asian American. He doesn't seem like a bad comparator to me. Are there cases that say when you have multiple possible comparators, one isn't enough? Is there anything out there we can look at on this?
The best case I can point to for that, Your Honor, would be the decision in Swain from the Third Circuit, where a police officer similarly attempted to point to one other officer's increase in overtime. And in that case, the Third Circuit said, no, that is just a speculative claim that that officer's situation would be like yours. And that's really the case here, too. It certainly would have been possible for Lieutenant Yee to compare himself to Lieutenant Lydon, or to compare himself more broadly to lieutenants at Troop F in general. We do not know in this record whether Lieutenant Yee made less than Lieutenant Lydon's $100,000. We do not know whether he made more. And absent that historical baseline, it is not possible to reach an inference under McCormick about whether a transfer would have meant, one, a difference, and two, a difference that would have been material to Lieutenant Yee under his own circumstances, because those circumstances aren't established in the record in the first place.
What does a lieutenant in Troop H do?
Well, we know in this record that Lieutenant Yee was a shift commander. I don't know the answer to the full range of them.
It's not at the airport. We know that Troop F is at the airport.
Correct.
So it's going to be a different job than what he has now.
It would be at least a different geographical location.
Okay,
from where
different
it is now.
focus. Focus is on the airport. What if the evidence were that Troop F, the people in charge of Troop F said, we only want white guys in Troop F? Would that be without a 151B remedy unless they could demonstrate that there were greater opportunities for overtime in Troop F?
I think that sort of evidence would certainly support a disparate impact claim. I think it may support a hostile work environment claim. I think there would be
But isn't that only, I mean, the issue is whether it's an adverse employment action.
Right.
If it turns out that an officer wants to go into Troop F for whatever reason, he wants to work at the airport, and there is evidence that says Troop F is only for white guys, is that an adverse employment action that he is denied the opportunity meaningfully to have a chance for that job?
I think it's the case, Chief Justice Gantz, that in any pure discrimination action under 151B, subsection 4.1, a plaintiff has to establish a prima facie case, and an element of that prima facie case is the adverse employment action.
Is it an adverse employment action, which we know to be an element of the prima facie case?
That hypothetical evidence would still not make what happened here an adverse employment action.
So, really? So basically, it would be the AG takes the position that if people in Troop F had said, you need to be a white guy in order to work here, that it would not be an adverse employment action to deny an Asian or a black or Hispanic that opportunity?
That's not the position we're taking, Your Honor. I think there have been...
So it is an adverse employment action?
No, that's not the position
I
I'm taking
want to know
either.
what your position is. I want to know why it's, I mean, I'm giving you... That,
I think
there's a difference in terms of the quality of evidence of discrimination.
Mm-hmm.
Put that aside. You may prevail in showing that there was no discriminatory purpose in the hiring, that it was perfectly legitimate and based on other reasons.
Mm-hmm.
But I'm asking, the issue is before us is not, that's a question of pretext. The issue here is it an adverse employment action? And so I'm saying that if they had evidence that was extraordinarily compelling of discrimination, if the evidence were as strong as it could possibly be, the people in charge of Troop F says, we only want white guys to be working here. would it be an adverse employment action if somebody were denied a transfer to Troop F on that basis?
I don't think that changes the nature of the adverse employment action inquiry. I would point to a case in particular. It's a very recent case. It's out of the D.C. Circuit. It's called, I believe, Ortiz versus Department of Housing and Urban Development, and it considered an issue close to Your Honor's hypothetical. And what the court said there is that, yes, in that case, if there's extraordinary compelling evidence that there's discrimination, but the adverse employment action sort of evidence is weak, that could still be actionable in different ways. But I think what we're actually talking about here is a much narrower case. We're talking about the sufficiency of Lieutenant Yee's evidence that he made in this record.
I understand that's how you want to frame it, but the fact of the matter is he's applying from Troop H to Troop F. It's a different job. One works at the airport, one does not. I know that his argument is that it focuses on the opportunity for overtime, and we'll get to your answer to interrogatory 12 in a moment. But is that not an adverse employment action if basically the world is that a non-white guy can't have the opportunity to obtain a job in Troop F because they only take white guys? Would an attempt to transfer there that is denied for that reason not be an adverse employment action?
If that were the evidence in this case, if it were conceded that Troop F only took white guys, then I can assure the court that we certainly never would have moved for summary judgment.
That's what his argument is.
Well, no, it's not, because the plaintiff in this case is proceeding under the indirect evidence framework of McDonnell Douglas.
But implicitly, the argument, as I understand it, is unless you're a good old boy who plays hockey, and unless you're in that circle of buddies who do it, you're not going to get the job, and an Asian guy's not going to get the job. That's the argument.
Yes, and we also believe that the plaintiff's evidence of pretext in that regard is insufficient.
I understand that. I'm putting that aside. I'm only focusing on adverse employment action. So you're saying that it would be arguably permissible for there to be places where discrimination is permitted and it's not an adverse employment action unless you can show that it is a promotion. That's your position?
No.
That's what you wrote.
No, our position, Your Honor, is that in a denial of lateral transfer case, consistent with the uniform view of the federal courts in this area, a plaintiff, as part of his prima facie case, has to show some evidence that the position that he sought was objectively and materially better. Some circuits, like the Third Circuit and Fifth Circuit, have said functionally like a promotion. Other circuits have said objectively and materially better.
So let's take that. So you're in the government division of the AG's office?
Yes, Your Honor.
Very prestigious. Let's assume you wanted to work in another division, arguably less prestigious, different type of work, same pay. But they say, sorry, we only take women. In there, you're not a woman, you're not going to be permitted to work here. Is that an adverse employment action? It's not it turns out that it's not a promotion, either in terms of prestige or income, but it's a denial of an opportunity for a transfer to a place that somebody would prefer to work. Under your theory, that's not an adverse employment action.
If indeed the only difference is that the plaintiff subjectively perceives a difference, then no, not an adverse employment action. If there is objective evidence suggesting that, say, administrative law is more prestigious than the trial division, then yes, there could be a fact issue.
So basically, unless it's an improvement in prestige or an improvement in income, it's not an adverse employment action, even if they say only certain people may apply, or only certain people will ever get the job.
Well, isn't there a question of what you have to compare? I mean, in the chief's hypothetical, where the Consumer Affairs Division gets paid the exact same as the Government Bureau Division, and the AG's office hires for both, and don't you have to compare? If there's no difference between the two of them, you analyze them together off in employment law, don't you?
Yes, and in a case like this, where we're talking about lateral transfers between divisions, I think what we see in the case law is that there have been many, many ways in which plaintiffs have succeeded in showing at least fact questions about adverse employment action. It could be there's an objective difference in prestige. It could be there's an objective difference in career advancement
If there
possibilities.
is a difference, then we start getting worried. But if there isn't a difference, we often have to compare the both. We don't necessarily divide the group in two, right? I just don't know the answer, but I thought that's the case.
We do compare, and the issue, the real fundamental issue in this case is that there wasn't an adequate basis in the record for a real comparison. I mean, there is no evidence here to suggest that Lieutenant Leiden's experience was either generalizable to differences between the two troops or representative of what would happen to Lieutenant Yi. We do not know why Lieutenant Leiden earned the amounts that he did. It could be that it was unique to his job, and there are a whole range of different jobs.
I'm now still worried about that because I just read Swain, the case you're talking about. And Swain, they don't have, it's more complicated because in Swain argues that a canine officer earned an additional $18,000 per year in overtime. The undisputed facts disclose, however, that most of this overtime was for unrelated activities. So it's not like Leiden. Leiden, we don't know if it is or it isn't. There they proved that it wasn't. So I still don't have any cases analyzing this issue, the Leiden issue.
Well, I'll give Your Honor one more case.
Okay.
The Garmin versus National Railroad case from the First Circuit is another adverse employment action case that involves an overtime issue, and I think the evidence there was in some ways comparable to the evidence here as well. My brother has pointed to...
Sorry, is that cited in your brief?
It's not. It was cited in the MCAD's amicus brief.
Okay, so it's somewhere we can track it.
Yes.
Okay.
Yes.
Okay.
And would you agree that it would be relevant evidence if it turns out that the lieutenants in Troop F earned substantially more in overtime and detail pay than other lieutenants?
If it were established in this record that there was a difference in general between the two troops, that would have taken the plaintiff a long way, but that was not established.
So then why in answer to interrogatory 12 did you initially refuse to answer the question?
I was not discovery counsel in this case, Your Honor. I do know.
Can you see any justification for not answering that question, given its relevance?
I think that the ultimate decision to answer that interrogatory was the correct decision.
Okay, so then what do we do with the fact that when the answer was given, the answer understated by, let's say, the true amounts are double and treble the amounts stated? What do we do with the fact that I don't know whether or not if someone had said, golly, if I knew that these guys were averaging $86,000 in overtime in 2011, I would be asking for information about what other lieutenants are making in other troops to be able to make exactly the comparison that would, you agree, get them over the hump.
That mistake that happened here, Your Honor, didn't make any difference to the outcome. Lieutenant Yi
Because it wasn't revealed till after the motion had been decided.
Lieutenant Yi has not suggested that he was induced to make a different record because of that mistake. The correct underlying information on which those averages were calculated was produced. It was produced as the very first page of the document production. Maybe as important as all of that, those averages themselves are still not indicative of anything relevant in this case because they do not provide a comparison between Troop H and Troop F, nor did they indicate anything about Lieutenant Yi's own historical baseline. We already knew from Lieutenant Leiden's testimony, Lieutenant Leiden makes $100,000 in a year at Troop F, $70,000 in a year at Troop H. We already knew in the record that it was possible to make a lot, both at Troop H and Troop F. The fundamental problem here was that Lieutenant Yi didn't show any evidence tending to suggest in any non-speculative way that the transfer would have made a difference for him.
Well, if it had turned out that the average for other lieutenants is half of what they're actually obtaining in Troop F, would that not have been important?
It was not important in this case. It was not important in the record.
It was not important because we don't have that data, or because it's not important theoretically?
It's not important in actuality because Lieutenant Yi didn't attempt to compare himself to anyone at Troop F. And so the average,
Well, what is Trooper Leiden then? I thought he was using Trooper Leiden as essentially a comparator.
he is, but when we scrutinize the record here, there is no actual comparison to Lieutenant Leiden. Lieutenant Yee has never said, here is what I have made historically at Troop H, and compare that to Lieutenant Leiden. So we disagree that Lieutenant Leiden is being used as a comparator here, nor is there any indication that these two are similarly situated, in that we don't know that they are two people who have always taken advantage of all of the opportunities that they can. We don't know that their jobs would look alike in any way at Troop F. So I don't believe that there is a comparison being made, and even if there were a comparison being made, I don't think the foundation is there for that comparison to be relevant here.
All right, thank you.
Thank you.